The recent legal battle that unfolded over control of Aretha Franklin's estate is a cautionary tale for families. The late Queen of Soul had two wills, which pit two of her sons against each other. And there have been other disputes over wills after the deaths of celebrities such as Prince, Michael Jackson, and Whitney Houston. But it's not just the rich and famous who need to have their final affairs in order. Morning Rush financial contributor ErikaBlair McGrew is here to help us out, sort through all of this. So this really came into focus with the Aretha Franklin ordeal, with them using the will that was found in a couch cushion. But this is something that affects all families.
Yes.
And you don't have to be rich and famous for
Correct.
this to impact you. And it can cause bitter feuds between family members. So just talk about the importance of making a will and when you should start planning one.
Absolutely. So, with a will, that is a legal document that is going to outline your wishes when you pass away, right? So it's going to be able to tell who gets what when you pass away. But like you said, with the Aretha Franklin case, now we have two wills and we have people challenging or contesting that will.
Is it better to start, like, the sooner the better for one of these?
Well, I actually think that you should have a will and a trust.
Explain the difference there.
Absolutely. So like I said, the will is a legal document that outlines your wishes, whereas a trust is a legal arrangement that is going to hold your assets. So with a trust, you can actually put your assets in the trust and outline how you want the distribution to happen inside the trust. Now, the difference between the will is the will has to go before the court. You have to go through something called probate. Probate can be a long, lengthy, time-consuming, and frustrating process. But when you have it in the trust, then the trustee can actually divvy out your assets to your beneficiaries from there.
So the trust is like a building blocks. It's where to start from.
Yeah, well, the trust is like a holding place for your assets that's going to make it easier. Because another difference is with a will, everything is public. So we're seeing the whole Aretha Franklin case play out in the public. But with a trust, your assets are private. Only the trustee and your beneficiaries know what's in there, and the trustee has the ability to divvy it out.
And I know no one wants to think about their demise, but what age? Is there like a number that you can pinpoint of when you should start planning for this?
I would say as soon as you have people who depend on you, whether those are dependents in the form of your kids or dependents in form of your parents, if you have someone who depends on you, then you need to have a will and a trust. And I would say that the recommendation is to put all of your assets in the trust and have the trust to outline how that is divvy up. And then you want to put things like guardianship and legal type of things in the will.
So let's talk about if you don't do this. What are the consequences of not having either one of these?
Well, unfortunately, I had to deal with this recently. My mother passed unexpectedly, and she did not have this stuff set up. And so I had to go through the lengthy process of finding out where her assets were. I had to find out whether I was actually named the beneficiary. I had to kind of like be a detective to see what was going on. And then I had to go through the probate process and get myself as the administrator. So it was a lengthy, time-consuming, furious, frustrating process, and nobody wants to go through that when they're dealing with grief.
And whether it was with your case or maybe someone else, have you heard of any disputes that get ugly over these things?
Absolutely. Like we said, the will is public. It can be challenged. It can be contested. And if the siblings or the beneficiaries don't agree with what was in the will, then they can contest it. But if you put those assets in a trust, there is no contesting to be done. The trustee has the right to follow the outline that the person gave.
So let's talk about just the first steps. What do you do first when you want to start a trust? Let's try that.
Well, you're going to go to an attorney. And a lot of people think, when they hear trust, they think wealthy people, rich people. No, you don't have to put anything in the trust when you open it. So you go to the attorney, you tell them what your goals are, and you tell them that if something should happen to you, you want all of your assets to transfer to the trust. So you don't have to fund a trust immediately. But your first step is definitely to go to an estate planning attorney, and they'll help you set up the trust.
And you don't have to have any minimum asset or anything like that. You can just go with what you've got.
Yes, you can just go with what you got, but make sure you know what your goals are and make sure you know what you want to happen to your assets if something happens to you, because that's how they're going to know how to best build a trust for you.
Otherwise, they're going to find a note in a couch cushion and just give it to somebody else, right?
Absolutely, yep.
ErikaBlair McGrew, thanks as always for coming on. We appreciate it.
Definitely, thank you.
Stay here on Scripps News. More Morning Rush right after this.